All right, enough of that music. It's Dave Brannen. I'm here for Ask a Lawyer Live, your weekly show. Well, I guess it's a daily show where I answer your questions live on the air. I'm a disability and employment lawyer based here in Canada. Today, we're going to be talking about the number 9 mistake from my book, this book right here. The number 9 mistake is failing to follow medical advice. This is one of the mistakes that can lead you to lose your long-term disability claim or have benefits denied. So let's dive in on this topic. So why does this matter? Insurers do expect you to follow reasonable medical advice once you are on a claim or have your claim approved. Now, failure to follow reasonable medical advice is a common reason for denial. It's a favorite reason for denial to be used by insurance companies or programs like CPP Disability. And even a single denial can be used against you. So beware. Certainly, CPP Disability is very focused on denying claims where there's been any type of a failure to follow reasonable medical advice. So what is reasonable? This is where a lot of people get caught up. Reasonable does not mean perfect. It means what a typical doctor would recommend based on accepted medical practice. So it is not what your own doctor is recommending, but more so what your doctor's recommending would be judged from the view of like, what would a typical doctor in Canada recommend in this situation? And what is the accepted medical practice for the type of treatment that's being recommended? Ultimately, a judge determines what's reasonable, not the doctors. The judge would base that on expert evidence coming from two doctors. If doctors both had different opinions, the judge would have to review and decide which one to accept. So ultimately, it does come down to a legal determination, and would a judge agree that it was reasonable? All right. Here's a story, a real story. I've modified the facts a little bit here just to protect the innocent, but it's a good story to show how refusing treatment can backfire or, not work out so much. So in this situation, we'll say it's Janice was a dental hygienist with carpal tunnel syndrome, and she refused to do a carpal tunnel surgery, which is anybody's right to do. But it's anybody's right to refuse surgery. But the long-term disability insurer took offense to that and said, look, we think if we're going to cut off your long-term disability benefits because we think if you got the surgery, you would be able to go back to work. Now, this client refused to do the surgery based on her own experiences and that of friends that she knew who did not have good outcomes with the surgery. When you look up carpal tunnel surgery, there is a risk that you could develop complex regional pain syndrome, which was what she was concerned with as well. Now, the question is like, how likely is someone to develop that type of a condition? Is it a real risk? And ultimately, is it reasonable to do the surgery? So to make a long story short, we consulted various experts, and the ultimate conclusion of the experts was, including this person's own doctors, ultimately was that it was up to her to choose whether to do the surgery or not, but the risk of developing like a complex regional pain syndrome would be extremely remote and lower even than is reported sometimes that you'll find on the internet and websites and things like that. So it was a very low risk. We determined, now the case never went to court, but we believe the court would have sided with the insurance company on this one to say that it was reasonable to do the surgery in her situation. Now, that doesn't mean that it would be reasonable in everybody's situation, but given her age and the type of carpal tunnel and all these kinds of factors, the risks were extremely low. Now, there might be other factors depending on the person's age and the type of carpal tunnel, their body structure. Like there could be other things that would raise their risk, and maybe it would be reasonable to refuse. So you shouldn't just say that it's never reasonable to refuse a carpal tunnel syndrome surgery. It would really depend. But in this case, we felt like a judge was going to find that it was reasonable to do the surgery. Now, so the legal principle is that you must the legal principle is that you must mitigate your losses. So what that means is you must make reasonable efforts to try to get better. And in this case, accepting standard low risk treatments like a carpal tunnel surgery would be refusing to do that would be considered a refusal to cooperate with treatment and a failure to mitigate your damages. So there sometimes can be alternative treatments. If you're in a situation where you're recommended more than one treatment, then it's important to know that you can't look at alternative treatments that would replace a conventional treatment. So alternative treatments can be added to conventional care but cannot be used instead. Courts typically are not going to accept acupuncture, naturopathy, unless it's approved by your doctor and it's done in addition to any other recommended medically accepted practice. You couldn't do it you couldn't do it as an alternative. So the best practices would be ask your doctor to always document whether the treatment they're recommending is necessary and to discuss the risks and the benefits of the treatment with you. You should always keep notes. If there's going to be something that you are really concerned about, keep notes around this. And if the insurer's doctor recommends something, make sure to talk it over with your doctor to just get your doctor's take on it. Now, if you disagree with our suggested treatment, if you disagree with the treatment, like I said, talk it over with your doctor, get a second opinion, and talk to a disability lawyer to get a take on like how would a court view this. Again, it's always your right to decline medical treatment. The problem is that some of your decisions can impact the disability benefits. So just like it's your right to choose to do or not do a treatment, the insurance company also has the right to deny treatment, deny benefits if they believe that you are refusing reasonable medical care. So just keep that in mind. So, summary of what you must do. You must follow reasonable medical advice and realize that what is reasonable is determined by a judge ultimately based on what is accepted medical practice. You want to avoid doing an early refusal. Rather, you should get more information and discuss it with your doctor and seek advice before outright refusing to do a recommended treatment. And ultimately, the more you engage with treatment, you will improve your credibility. So really, you want to reserve refusing treatment for the last resort. Ultimately, you should default to when you can, you should always try to go through in good faith and do any recommended treatment. It will work out much better for you in the long run. All right, that's enough of that. Let's see if people have any questions. You can put those in the comments. While we're waiting for questions, I am going to check in on the forum to see if we have any questions that I can answer. It does not look like there's any new questions today. Huh? Surprise, surprise. No, there might be some questions here. Hold on. Let me see. Yeah, if you have a question, just put it, type it out in the chat there. While I'm waiting for people to type them out, I'll just look at my share the screen here. Let's take a look at the forum. Okay, here it is right here. So this is our disability claim forum where people post questions and I will answer them live on the air here and also typing in answers. So here is a question. In case I need to litigate to get LTD from an insurer, litigate means just file a lawsuit against them. I'm wondering if I'm eligible to take EI for disability after short-term disability, or does the XX weeks of short-term disability kill my ability to get EI? Yeah, this one I don't have the perfect answer to. I do think you can get the answer lies in how they calculate the weeks of EI. So if you would still qualify, if your short-term disability was short enough then you can tack on the EI after the short-term disability. I have heard of people doing that, but it does depend on how many hours you have. So, it is something you can always double check with EI about. I'm just looking it up here now. I'll switch my screen over here if I find what I'm looking for. Yeah. So to qualify, let's just switch our screens here. To qualify for EI, you must share the screen here first. Let's see. Okay, here we go. So you can solve questions like this just by going and looking at what's required. Here we are. Whoops, that's the wrong thing. This one. There it is. So do you qualify for EI? To qualify for EI, you must have accumulated 600 insured hours in the 52 weeks before you start your claim. So what would happen is when your short-term disability is over and you're applying for EI, they're just going to look at this number like, do you still have 600 insured hours in the 52 weeks before you start this new claim? If you do, then you can go and get EI. What you can't do is like retroactively get your EI so that it overlaps with your short-term disability because you would have to repay the EI. Like the EI would say that you don't qualify because you've already been paid. So it would depend on how many insured hours you have, and that after you are finished your short-term disability, say for 3 months or however long it is, they would then, as of that date, they would look back over the 52 weeks before that date and see if you had 600 insured hours. If you do, then you could qualify to get EI sickness after getting the short-term disability. Hmm. Pretty sure that's right. I don't do a lot of work with EI sickness, so I would always encourage people to reach out to them and see what they say. It says from the start of your claim. So I'd want to know what it means to be the start of the claim. Likely that is going to mean like you're going to start the claim after the short-term disability is over. And I think that's still going to be fine. I don't think they're going to backdate it. I know for a fact that people have gotten EI after getting short-term disability. So this is definitely something you can do. All right. I may just go back here for a second and answer this question on here before we move on to someone's posted a question. So I'll get to the question posted in just a second. Let me just finish this off by answering this question here live on the chat, in the chat. Okay. All right. So this is what I think. This is what I would think, but there. Sometimes they can have internal policy changes that will make a different answer, so that the general public like us aren't going to know about. So I always recommend people reach out to Service Canada. There we go. Okay, let's look at this question we had posted. Let's get rid of this. Oh, sorry, I wasn't sharing my screen. There, I just typed in the answer here. Sorry, folks, I thought I was sharing. So I just typed in, as far as I know, you can get EI sickness after short-term disability ends as long as you still have enough hours to qualify. EI looks back 52 months. It's not 52 months. It's 52 weeks. Whoops. Let me fix that. There. There we go. Hopefully that's better. So when they look back, if you've got the 600 insurable hours, then you should be able to get it. They can't be overlapping. That's for sure. Okay, let's get rid of this and take a look at this question. So this person says, I have a pending short-term disability that started in May 16th, pending doctor's visit on June, terminated on, so pending short-term disability. Okay, so the short-term disability started in May, doctor's visit on the 11th of June, but basically fired a few days ahead of the doctor's visit. So I assume that this person that you're writing in here, that you've been off work and your short-term disability, you've been off work, but the short-term disability claim is pending. You've got a doctor's visit coming up. And in the meantime of all this, your doctor or your employer terminated your employment. It could be a wrongful termination. Yeah. I'd need to know a lot of details. You don't have to put them here, obviously, but the details that would be important would be, what were what did the employer state was the reasons for the termination? Did they pay termination pay? Is there any, like, whenever you have a termination this close to someone going on a short-term disability, it does make it that it could be discrimination based on disability. That's what it looks like it could be. But sometimes the employers can prove that that was not really, it's just a coincidence that they were going to be ending your employment anyway, or if you're being terminated along with other people, so that there's ways the employer can prove that this was not disability related. But if they can't prove that, then the assumption will be that it was related to disability. Not necessarily in your case, but in most cases where there is somebody's terminated very close in time to going on a sick leave or something like that, or coming off a sick leave, it's often that's what will be presumed unless the employer can prove that it wasn't. That's how it works with human rights. Like, you have to prove that that on its face it appears that there's discrimination just based on the facts. And once you establish that, then it shifts over to the employer to prove that it wasn't related to disability. So this person's clarified something here and said, oh, no, this is a different person. This is a different question. So, bit of a disability topic. How are the episodes number, please? Just to me to understand what I'm looking for information. Yeah, so the episodes are just numbered sequentially, and sometimes when I'm in a rush to get them up, I sometimes get the numbers wrong, so I have to go back and fix them. Like, for example, let me just go have a look. They're just numbered sequentially. Like, this one is saying episode 47, but that might be incorrect. I didn't have time to double check it. Let me see. Yikes. I don't want to see the live episode. Let's see here. Resolute. There we go. So, oh yeah, no, I got the episodes totally screwed up. Yeah. So this should be episode 40. This should be episode 50. I'll go fix that afterwards. And yesterday I had episode 30. Yeah, sorry. I've been in a real rush the last couple days. I've just with busy, so I've been trying to get this stuff up real quick. And it was a typo. So the episodes are just sequentially by how they happen. Yeah. So the last two ones are just an error. In fact, I could fix that right now. Let me see if I can fix it right now without ruining the whole stream. Can I fix it? I think I can. So so yesterday's should have been 47, 48, should have been 49. I don't know why it says 32. That's hilarious. So 49 was yesterday, and today is 50. Don't know if I can edit this while it's going. Yeah, it looks like I can. All right, I guess you can. I guess I can. There. There we go. That should be fixed now. That's how it is. It's just they're numbered just as the episodes go. Okay. Sorry, I had the phone and scroll at the bottom there. I'm not really taking the phone calls today. Let's go. Just put your questions in the chat if you got them. Now, there's another question here, just to follow up. No termination pay, no others. Reason was no one was in my position and they needed someone in my position. Oh, I see what you're saying. They hired someone else. Yeah, look, it'll depend on where you're at. I'm assuming you're in Canada because sometimes we get Americans on here, but the law in Canada will be different depending on your province. But generally speaking, if you're terminated, you would be entitled to some termination pay. You can't just fire people in Canada and not give any termination pay. You can do that in the US, but in Canada, that can't happen. Only in very rare circumstances, but certainly not if you're being fired for being on a sick leave or something like that. So it would depend. You could always reach out to us if you wanted to get a consultation and we could review your situation. But generally speaking, you're going to be entitled to minimum termination pay under your province's Employment Standards Act at the very minimum, and sometimes more than that. But again, it's very factually dependent. So we wouldn't be able to get into enough details here for me to give you any definitive answers. Certainly, it's a red flag. If you're being terminated, it's employers are allowed to fill positions while someone is off on sick leave. You're saying they terminated you. Like, did they actually give you a notice of termination, or did they just fill your position with someone else while you're off on sick leave? That would be something else you'd want to know. Now, if you work in the construction industry, I should say, like, things can be a little different there because people in the construction industry aren't automatically entitled to termination pay. So there's a lot of questions that would need to be answered. But if you wanted to get a consultation, you could just contact us through our website, and we could look at it for you. So this person's saying they called and fired me on the spot immediately following my job was advertised. Wow. Yeah. Definitely sounds like you would be owed termination pay. So watch your next pay check to see if you get it. Um, if you don't, then again, like reach out to us or another firm to get some advice on what to do. There's so many factors that we need to look at. Like, for example, was there anything else that they said you did inappropriate or things like that that could be reason grounds for them to fire you without pay? Like for you to be fired without pay, you'd have to have done something wrong apart from just not being able to work because of disability. But I don't think you should air out all your dirty laundry, or I'm not saying you have dirty laundry, but I wouldn't go into a lot of details on here. Probably just get a confidential review of your situation. It may not make sense to have a lawyer represent you, but if you're just owed termination pay, you can go through the labor board or the government agency in your province that enforces the Employment Standards Act of your province. Like I say, at the minimum, you'd be owed some money, most likely under the Employment Standards Act. Then, depending on the details of your employment, you could be entitled to more termination pay. You in theory should be able to, if you have enough hours, you should be able to get uh, employment insurance benefits as well. Great on. Any other questions from folks? See if there's any other things on this on the. See if there's anything else to look at. Yeah, it doesn't look like we have any questions on the. I think I've covered everything on the website there. I'll just move on to my book here. So this was the book I was mentioning at the beginning. I was going over mistake number 9, which was failing to follow medical advice. So that's all covered in the book in the section that goes over the mistakes, the 11 mistakes that can ruin your claim. You can read that over. If you want a copy of this, you can download a free copy in the down below. There's a thing you can click on to get a copy of a PDF copy of the book. We also mail out paperback copies to people who are dealing with a disability claim. So there's a way you can also order that as well. All right, we got someone asking for an update on the CDB, sorry. Let's see if there is one. The CBD is the Canada Disability Benefit. Are there any updates? No, doesn't appear so. We're all kind of waiting because the applications are supposed to open. The ability to put in an application is to open this month, but likely not until it could be like the final day of the month. They're probably scrambling to get everything put together. So I expect that it won't happen until near the end of the month. We'll see this roll out. But no, we don't have any. There's nothing, no updates that I can see. I think the applications will go online. So the most likely place you're going to see it is in your My Service Canada account. I believe at a certain point, it's just going to appear in the My Service Canada account online. When you log in, you will see a section on the Canada Disability Benefit and an ability there to submit an online application. I'm almost certain that's how it's going to work, because why would they go back to paper? So they must still be programming it, testing it, getting it ready to launch is probably what's happening. Service Canada also, now it does link through, I assume it's going to be through My Service Canada because they're the ones operating it, but most of the information they need to assess your claim is going to come from Revenue Canada. So again, it's possible that the Canada Disability Benefit could be managed through the Revenue Canada, your My Revenue Canada. I don't know if it's the same. I think My Service Canada, maybe it is linked to Revenue Canada as well. I haven't logged into it for a while. But if you can log into your online Revenue Canada account, it also could appear in there because it is very much dependent on information that is managed by Revenue Canada, like your taxes for the year before and the disability tax credit as well is managed through Revenue Canada's website. So it's going to be one of those two websites for sure. All righty. Just bear with me here. Is there anything else I can review with you folks today? Um, yeah, one interesting thing. So, um, I was dealing with an interesting issue today involving people who have stock options. Now that doesn't apply to most people, but stock options are an interesting thing because they have to vest, which means when you get these types of options, they're given to you, but you only will get them if you continue to be employed for certain amounts of time. And one of the issues that comes up is if you go on disability leave, do your stock options continue to vest while you're on disability leave? The answer to that is actually quite complicated and will depend a lot on the wording of the kind of stock option plan that you have. And also, so it's very dependent on the wording. Often it will focus on wording that says that you have to be actively employed, so that unless you're actively employed, so i.e., not on a sick leave, then your stock options will only vest while you're actively employed. However, courts have said that if it's vague language and if it doesn't mention, if a person's on long-term disability benefits and it's not mentioned, there are avenues where you could argue that these things still vest while you're on a long-term disability leave. That's kind of how we looked at it in the person I was giving advice to today, that there's a good possibility that their benefits could still vest. But it's interesting. It's interesting. Can get complicated. Other things you look at is has the employer acted like these are still vesting while you're on long-term disability leave? So in some cases, they might have issued more options while you're and give them to you while you're on a sick leave. That would tend to show you that they intended that these would continue to vest while you're on a leave. Again, not something that most people are going to be dealing with, but if you are in a situation where you're dealing with do certain benefits vest, or that means that you get entitlement to them, that is something you often have to take into account when you're doing a disability claim. All right. I think I'll leave it there. Short day today, but we don't always have to go long on these streams. If anyone has any other questions, I'll be back tomorrow. I'll be taking Thursday and Friday off because I'm going to be attending a conference in St. Andrews, New Brunswick, legal conference with other lawyers for like legal education. And yeah, I guess I'll see you all back here tomorrow if you're around. Otherwise, have a good day.